common law assault for two reasons. First, it was not objectively offensive.
Ms. Wing, I'm sorry to interrupt you. Did you want to reserve any of your time for rebuttal?
Yes, I intend to reserve 3 minutes for rebuttal.
Okay. And if you could, thank you.
Okay. The touching in this case was not a common law assault for two reasons. First, it was not objectively offensive, meaning it would not cause fear, shame, humiliation, or mental anguish in a person of reasonable sensibility. And second, it was not intended to be offensive. The government argues that the crime of assault also covers reckless offensive touching, but that was not part of the common law meaning of assault that Congress incorporated into the simple assault statute in 1901. And such expansive liability is contrary to tort law, the model penal code, and the overwhelming majority of state assault statutes. The common law authorities cited in our brief make clear that the intention or purpose to inflict injury is essential to an attempted battery assault, just as this court said 100 years ago in Patterson versus Pillins, and more recently in Alfaro, Williams, and Buchanan.
Ms. Wang, I know that your brief spends time talking both about the actus reus part and element of assaultive conduct and the mens rea element. So I just want to start with the mens rea element for a second, because in your brief you talk a lot about the confusion surrounding our case law, where we talk in some cases about there being a general intent to commit the act, and in other cases we say you need a specific intent to injure as well as committing the act. And generally we're confused by these terms, specific intent, general intent, and I remember in law school being quite confused by those terms as well. But you don't seem to be enthusiastic about embracing the model penal code, which we incorporated somewhat in our en banc decision in the Carell case. Purposefully, knowingly, and recklessly intending to commit an act. Why is that?
It's not that I agree with Your Honor that this court should abandon reliance on these confusing terms of specific and general intent. And I agree that this court should clarify that the mens rea of simple assault in terms of purposely, knowingly, or purposely or intentionally, those words are used interchangeably, knowingly or recklessly. What I disagree with is the notion that we should adopt what the model penal code says assault is, because that is not what our statute does. Our statute incorporates the common law elements of assault, and unlike the majority of states in this nation, our legislature has not adopted a new statute that defines the elements of simple assault the way that the model penal code has. So I think that because the common law authorities say that an assault requires an intention to inflict injury, that this court should say that, an intentional infliction of injury.
So you'd be okay with purposefully and knowingly? You have some concerns about recklessly?
I definitely have concerns about recklessly. As to knowingly, the courts and the model penal code have both said that there's very little daylight between purposefully and knowingly. And we certainly agree that a fact finder could infer purpose from knowledge, knowledge meaning substantial certainty that the result will occur. And so when a person intentionally does an act with knowledge that the result, substantial certainty that the result will occur, then I think it's usually a fair inference that they intend for that result to occur. However, I do think that since the common law authorities do use the word—
That sounds a lot like the government's position.
No, the government says that not that there's knowledge of substantial certainty that the result will occur, but that there's a risk that the result will occur. And so that's recklessness is very distinct from knowledge in the sense that knowledge requires almost certitude that the result will occur, whereas recklessness is just a risk.
Do you have examples you could talk to us about that might make this more concrete, sort of paradigmatic examples that would differentiate what you're talking about with purpose, intent, knowledge, and recklessness?
Yeah, so before I do give an example, though, I would like to say that I think this court should stick with purpose. And the reason is that the common law authorities don't distinguish between purpose and knowledge. And a purpose standard is more consistent with the common law definition of assault as an attempt to commit a battery. And at common law, an attempt required a purpose to commit the crime and an intention that the result occur. But an example of the difference between purpose, knowledge, and recklessness. One of the examples, for example, given by the restatement of torts is a person who drives a car across a muddy puddle and where there's a pedestrian nearby. And if the person sees that pedestrian and says, you know what, I would really like to offend and humiliate this person today because that person is my enemy and I really want to offend them and make them feel humiliated today. And so they intentionally drive the car in order to splash mud on that person. That would be intentional. The purpose is to cause fear, shame, humiliation, or mental anguish on that person. Knowledge would be that almost the same thing. I know that that's going to happen, and I may or may not have a purpose, but I know with certainty that that's going to happen. And recklessness would be, I don't intend. In fact, I desire that that person not be splashed, but I'm aware that there's a risk that if I drive in a certain way, that person will be splashed, but I actually do not want that person to be splashed. And yet I drive in a manner that creates a risk, a substantial risk that person.
Now, are you sticking with the purpose, the higher level, because of the common law relationship or the use of the specific intent term, and the fact that it's an assault, like an attempted battery, and if that's what brings you there, is it coextensive with our attempt statute? Is it somewhat different? How do we know? Because I've read in your briefs or the government's briefs that the attempt law kind of developed later after that. How do we know what the difference is and how far you have to go to commit the offense?
Well, I think that I agree that the attempt law is very confusing, and it may well be as confusing as the existing assault law. But I think it's actually very clear that at common law, when Congress enacted the simple assault statute in 1901, the common law authorities say that an attempt requires a purpose, a desire to commit the act. And I don't think that this court needs to decide the difference between purpose and knowledge in this case because there was no evidence and no finding of Mr. Perez-Hernandez's knowledge with substantial certainty that the complainant would feel fear, shame, or that an objective person would feel.
But on the facts of this case, where the complaining witness specifically said, "Don't touch me,"
Yes.
How can you say that there was no knowledge on the part of Mr. Perez-Hernandez when he then touched him after
yes.
he had explicitly been informed by the complaining witness that he didn't want to be touched?
So I think that's a good question because it highlights the distinction between unwanted and objectively offensive. I think that there is certainly evidence, sufficient evidence that Mr. Perez-Hernandez had knowledge that Mr. Tarawali did not want to be touched, but not every unwanted touching, even after a warning, is objectively offensive. And I think that's best illustrated by a few examples. So imagine a man is walking along with his mother, and she reaches out to hold his hand, and he shrugs her off and says, "No, Mom, I'm a grown man. This is embarrassing. I don't want to hold hands." And she nonetheless grabs his hand and says, "Oh, come on, that's so silly. You're not too old to hold my hand." Okay, no objective person, a person of reasonable sensibility would feel fear, shame, humiliation, or mental anguish at that touch, despite the fact that it's.
Why do you use as the measure of what is objectively offensive these adjectives, fear, humiliation, shame, and the like? Is that something that you perceive to be deeply rooted in common law, or where do you get that
That language
metric?
is from, and the government cites it in its brief too, that language is from Beausoleil, this court's decision that describes the kind, drawing from the common law authorities, describes the type of emotional injury that is sufficient to constitute an injury within the meaning of an assault.
Is it set up in Beausoleil as expressly the test of what is offensive?
So Beausoleil says the threat or danger of physical suffering or injury in the ordinary sense is not necessary. The injury suffered may be the fear, shame, humiliation, and mental anguish caused by the assault. So those are, I think, illustrative terms. I'm not saying that they're exhaustive, but I think they illustrate that there has to be, all of those words have something in common, which is that they describe a heightened sense of, a heightened emotional injury. It's not just irritation. It's not just, I don't like that. It's fear, shame, humiliation, mental anguish. Those are.
Is that
do you think-
consistent with the fact that so many authorities at common law, going back to Blackstone and before, in so many cases, talk about how any contact, no matter how slight, can support can provide the actus reus for an assault. If that is so, it seems like, gee, however slight, doesn't seem to comport with shame, humiliation, and so forth.
Well, I think that just goes that a very, very slight touching, the gentlest touching of all, can cause fear, shame, humiliation, or mental anguish, depending on the context.
I know, but Blackstone doesn't say, of course, I'm only talking about very slight touchings that will cause fear, shame, humiliation, and the like. They're talking about the integrity of the person.
I think that I agree that Blackstone, which is one sentence that devoted to this topic, doesn't. I don't think that is sort of the end all be all of what the common law meant by offensive touching. I think if you look at some of the cases granted there are not as many cases about what it means to be an offensive touching in the common law, but they do say, including Lynch, a case that the Supreme Court cited in Johnson as describing what common law force or violence meant, says that it depends on the circumstances. It depends on the relationship between the parties, the type of touching, the context, the social context, the words that accompany. Because
You're going to put all that in a jury instruction?
I think you can. I think that a jury should be instructed. The jury's already instructed. The current Red Book instructs the jury that at least with respect to sexual touchings, which are a type of offensive touching that was considered a battery at common law, that a sexual touching is a touching that causes a person of reasonable sensibility to feel fear, shame, humiliation, or mental anguish. That's already.
Counsel,
I'm sorry, that's not true. It's objective. It's a person who it would be offensive to a person of reasonable sensibility.
Counsel, why don't we understand this in the context of protecting public safety? Right? I mean, after all, we're talking about the criminal law here, right? So the touching, however slight, is referring to, right, the punch that doesn't quite land, right? That you don't have to be hurt. The question is whether or not you're put in a position reasonably to feel unsafe, right? Which you do if you're touched in a sexual way without consent, which you do if someone tries to punch you, which you do, right, if someone spits on you, right? You feel unsafe. It's a personal safety thing. Is this really about protection from irritation, annoyance?
No, I don't think it is about irritation or annoyance, which is why I think that those words in Beausoleil are important to make clear that the quality of offensiveness is not just annoyance, it's fear, what Your Honor just talked about, shame, humiliation, mental anguish. And I think that though.
Do we have any, are there any common law cases that are about shame? I mean, I'm just,
Well,
I
the
know
sexual touchings are
I know it was
definitely about shame.
described that way in Beausoleil, but where are the cases? I mean, I only see cases where it's actually people being made to feel in fear or some sort of powerlessness, which seems related to that, right? And that seems to be the proper concern of the criminal law going back to the common law. But I'm not sure where this understanding of I get to declare my personal space and everyone has to respect that comes from in the common law.
I think that to answer your first question about where does shame come from, that I think is from some of the sexual touching cases, that even if it doesn't inspire, even if I think one of the examples was, back in 1800s, a man putting his arm around the neck of a married woman, that was considered extremely demeaning and would inspire shame or humiliation if done without her consent. It would also inspire fear, probably, perhaps, if it was sort of an overture toward a sexual assault.
I mean, there was sort of a power imbalance back
Yes,
at
exactly.
that time.
No, I agree. I think that to rise to the level of an injury that is going to be punished by the criminal law, that this court should be careful in defining. I think this court, unfortunately or not, this court is kind of stuck with the common law definition of assault, and I think that the common law makes clear that you do not need it does not need to be a harmful contact in the sense of causing pain or physical impairment, which is how the model penal code defines harmful. That it can be an injury to the emotions, but it needs to be of such a heightened degree that the criminal law that is worth protecting using the full force of the criminal law. So I agree, Your Honor.
I'm thinking
that
about your example about the mother wanting to hold the son's hand.
yes,
And I think I share your reaction that would not be an assault, what you described. But I'm not sure that the reason it would not be an assault is what you suggest, because I don't think it's an example of don't touch me. I don't want anybody touching my body. It's an example of I don't want to communicate to anyone who sees us that I'm a little boy and you have to hold my hand for that reason. I find that embarrassing. It's not a don't touch me, it's I don't want to convey that. Or it's something like
Okay.
that. But I dare say that if I approached the man in your example and just grabbed his hand, I think that probably would be an assault.
absolutely, yes.
I think if the mother in your example at some point put her arm around the son and gave him a little hug, that probably is not an assault. If I did it, I think it would be. I think in your example, therefore, there's something about the relationship
Yes.
between the two people.
Absolutely. That was the point of the illustration. Is
Right.
that,
Suppose in
is
your
that just,
example, the son says, "Mom, you're embarrassing me. I'm ashamed to be seen with you in public. I'm not a little boy. Take your hand off me." Does that satisfy your test for shame, embarrassment? Many men have
don't-
felt that way.
well, I mean, they may feel that way, but it's not the type of thing that the criminal law is going to protect. I don't think that a person of reasonable sensibility is going to say, if my mother continued to touch me after I told her it was really embarrassing, that it would cause fear, shame, humiliation, or mental anguish. Maybe a peculiarly sensitive person would, but that is not what the common law protects. And I think that
Suppose the man is in front of his buddies, and he's trying to portray, I mean, I think, I question the workableness of this test, frankly.
I think that the workableness of this, juries, fact finders are asked to decide what a reasonable person would feel all the time in self-defense cases, in federal obscenity cases, the Supreme Court has said that in an obscenity case, it's about, what is patently offensive according to community standards.
Well, if we're focused on what a reasonable person would feel, why isn't the complainant's reaction here at being touched after saying, "Don't touch me," in the middle of whatever their general relationship, in the middle of a disagreement, it seems like, why isn't it reasonable to think that's offensive? I mean, I don't know about the gravity of the offense, but just if the question is, would a reasonable person be offended?
Right.
Why wouldn't
Because
they
I
be?
don't think that the complainant's reaction was of one of a reasonable person. I think he was a peculiarly sensitive person.
Well, I'm just asking in general, if someone walks over to you who you don't know or who you're angry with right now
Right.
and touches you, and you say, "Don't touch me. I don't want to be touched by you right now," and the person touches you again, wouldn't you be offended? And if not, I mean, if so,
Yeah,
would it be
I think
unreasonable?
that illustrates the importance of the relationship. So a total stranger who comes up to a person on the street, grabs their hand and the person, and I say, what are you doing? Get off of me.
You're not
And they
suggesting
insist
that
on.
a friend can't assault another friend, are
No,
you?
I'm not suggesting that. I'm saying that a touch on the arm during a conversation, which is
I mean, we had a soccer game, very emotional, and we had a winner and a loser. I forgot who won and who lost, but Mr. Hernandez and Mr. Tarawali were on opposite sides of a highly charged game. You know, soccer is big, and they were at a soccer party, and one has lost and the other has won. And I believe Mr. Hernandez's team won, and he's kind of, jokingly, if you will, but he's taunting the loser, who's already upset about losing, and they know each other, they're friendly, maybe not the best of friends. And Mr. Tarawali says, don't touch me. I don't like to be touched. And he says it more than once. And then in response to that, Mr. Hernandez, it's like this commercial, stop touching me, the little kids. But these are grown men, and they're highly charged, because one is lost, one is won, they love their teams, and he touches him again. Why isn't that an offensive touching within the meaning of our assault statute?
So I have
And
two
with the surrounding
answers.
circumstances?
One is that there's, Mr. Tarawali, there was actually no evidence or finding that this was highly charged. I mean, that defense counsel actually made that argument, but Mr.
say
Tarawali
they were
said he
excited.
did not really care that much. So yes, there was evidence that Mr. Tarawali had been rooting for Brazil. Mr. Perez Hernandez said, Brazil lost, but don't feel too bad because at least you didn't lose any money on it.
I'm sure he didn't say it like that.
Well,
They
there's
love
actually
their
no
soccer
evidence of how
teams.
he said it. That's the problem. There actually is no evidence of how he said it, and it matters how he said it. If he had said it in a sympathetic tone, then that would be very different from saying it in I don't know. It's actually hard for me to even come up with a tone that would cause fear, shame, humiliation, or mental anguish, unless there were testimony about how, that there was, extreme, it was a threatening tone of
Say if
voice,
he
for
said it in
example.
a friendly tone. Hey, sorry you lost.
Yeah,
And Mr. Tarawali says, well, don't touch me.
right.
I mean, how does that change the
And I
the
think that the fact that
dynamics?
he touched again, going back to the topic of Brazil losing, is that he's returning to his original topic of, sorry you lost. I think, here's another example, okay?
Saying it
Say-
was a comforting touch?
Could be, I don't know. I don't think there's enough evidence for a fact finder to find beyond a reasonable doubt that the demeanor and tone and expression that was going along with that touch was either of a quality that would cause fear, shame, humiliation, or mental anguish in a reasonable person, or that it was intended to cause that. Now,
Could I ask you to get back to the mens rea
Yes.
issue for a moment?
yes.
I wonder whether your position with regard to recklessness, and for that matter, your position with regard to knowledge as sufficient mens rea, is consistent or inconsistent with our cases. I'm thinking of the fact that in Carroll, for example, where we discussed the cognate offense of threats, knowledge was enough. And I'm thinking of cases like Vines and other cases involving armed assaults, for example, where we've said recklessness is not enough. Now, in those cases, if recklessness was where we said recklessness was enough, and in those cases, if recklessness was sufficient, it was sufficient because it's an element of assault, not because it's an element of while armed. So haven't we already decided the mens rea issue is pretty much against you on this?
So let me deal with Carroll first, and then I'll deal with recklessness. So Carroll was deciding the threats statute, which it was not predicated on what the common law meaning of threats was. So that, I think, is a huge distinction. This court was not looking at what I don't even know if threats was a common law offense, but it was sort of applying general background principles of statutory interpretation that the Supreme Court had applied in Alanis. So I think that's an important distinction, that here this court is looking at what the common law elements were of assault. And then as for recklessness, I agree that this court has held that in ADW cases that reckless is enough. And I think that is consistent with the common law. The government cites, all of the cases the government cites for its proposition that recklessness was recognized at common law involve the reckless use of guns or other dangerous weapons, which inherently involve a substantial risk of death or serious bodily injury. That's the definition of.
That's what makes them reckless.
That's
But
what makes them
other
dangerous
things can
weapons.
make them reckless too.
Yes, and so while it may be the case that the common law will predicate a simple assault on disregard of death or serious bodily, a risk of death or serious bodily injury, there is no case that the government has cited, and I don't believe, I don't know if this court has said this explicitly, that simple assault can be predicated on disregard of a risk of mere harmful or offensive contact. That's a very different type of, there's a big difference in culpability between disregarding the risk of death or serious bodily injury and disregarding mere offensive contact.
Ms.
And there's
Wang,
not a single,
I'd like to ask you about your mens rea test. As I understand it, you say the defendant has to subjectively intend to cause offense?
yes,
And would you combine that with purpose and knowledge, which we seem to be fond of these days? Assume a defendant is credited when he says, I knew Judge Fisher would find this offensive. I purposely did it anyway, but I did not intend to cause offense. I was just funning around. Is he guilty of offensive touching or not?
I think that if the fact finder does not find intent, an intention to offend, then the person is not guilty. But I think in the vast majority of cases, that's going to be very difficult for a fact finder to say, okay, you knew with certainty that this action would offend, and yet somehow, it's almost illogical to say that wasn't one of their purposes.
Perhaps your test then is illogical. If it is known, and if he acts purposely, knowing what result will follow, then why should we look to a subjective intent to cause offense?
Because that's what the common law required. I think the common law in all of the cases say an intention to injure, a deliberate design to injure, a purpose to injure. Those are the words that the common law used. That's what this court is bound by. Now, I think that it's absolutely fine for a fact finder to be instructed that you can infer purpose, intention, whatever the words you want to use, from knowledge. That is absolutely permissible, but I don't think this court has a solid basis in the common law for using knowledge as the standard. But I don't think it matters that much, I guess is what I'm saying. I think in the vast majority of cases, it's not going to make a difference. And so I don't think this court should be that concerned about it, but it should stick with purpose.
Switching back to objectively offensive, you seem to be using that term as a way of distinguishing de minimis conduct that the criminal law should not punish. Or does the objective test serve any other purposes?
Well, I think the objective test serves the purpose you just identified, which is that if it's not the case that just about everyone's going to find it offensive, then it's not going to be objectively offensive. And so it needs to be something that is really clear and, in the words of Ray, highly offensive, that spitting is highly offensive. I think it also serves the purpose of, that the reason why the criminal law in general uses a reasonable person test and not a subjective person test. Because it's really hard to govern your conduct based on what a sort of eggshell victim might be feeling. That's true in, tort law. It's true in lots of things in criminal law.
Let me give you a hypothetical. Are you familiar with the prank known as a wet willy?
Yes.
So, grumpy old septuagenarian Judge Fisher, you're a complete stranger to me. You walk up and you give me a wet willy. is that objectively offensive or not?
A total stranger comes up to you and gives you a wet willy. I think that, yeah, I think that a total stranger using saliva on your person, yes, that spitting on a person is, so I think that the fact that he intends it to be funny does not make it, I think that you can intend to offend someone to be funny. I mean, a practical joke can still be a crime in the sense of, I can intentionally punch you in the face and intend for it to hurt, but do it because I think it's funny, because I want to make everyone else laugh. Your motive doesn't change.
Let's take a hypothetical that would not be offensive to most reasonable people. Take the famous hypothetical that the restatement uses of the butterfly situation. Most people, most reasonable people, have no problem with a butterfly alighting on them. But there are some people, perhaps, in the hypothetical, who are personally very afraid of butterflies. And a person, knowing that, decides to put a butterfly on the person's neck. Haha, it's very funny. And the person has a heart attack and dies from the butterfly. I think your test would say that that is not an assault. Or take another example of a case. This is a real case. A woman with unique religious beliefs goes in for a cesarean. And she tells the doctors, look, I know I need this cesarean, but I do not, my religion is such, I do not want a man to see me naked, so this surgery has got to be performed by a woman. And they agree. Now, when she's under an anesthesia, a male doctor does the actual work. At least one court has held that to be an assault. But I think under your test, it would not be, because you would say that, look, a reasonable person would simply not be offended by a male doctor doing this.
So Your Honor's examples are...
How does your test deal with examples of that sort?
Well, Your Honor's examples are precisely what the American Law Institute considered when it was considering amending the Restatement of Torts to define battery as causing harm with the knowledge that that this would be injurious to another person. And the ALI said, we're rejecting that because it's not supported in the case law. In fact, it's contrary to most state statutes and jury instructions. And so while there may be some cases out there in the modern world that are modifying their definitions of assault, whether by statute or whether in the common law context of tort, this court is bound by the common law definition of assault. And the legislature can change that if it wants to. The legislature can create the crime of, it can redefine assault however it wishes. But I would note that, the vast majority of state legislatures that have considered this question have decided that 21 of those states have said offensive contact is not an assault at all. We're just not going to punish that. It's not even serious enough to be a crime.
If we're
And
trying to interpret and apply the common law, why do we care what state legislatures have done?
Well, I don't think you should, but I think that I was trying to answer Judge Glickman's question of sort of policy-wise, shouldn't we care about the butterfly example or the cesarean example? And I was saying, well, a lot of state legislatures have said that they are not going to treat that as a crime. That could be a civil action, perhaps, but...
See, I'm not 100% sure I'm convinced that your reading of the common law is correct. But I take it you think that if the examples I gave you came up in 1900 before a very smart, knowledgeable, good judge operating in the common law, that judge would find no assault in either of those examples. I'm not so sure I believe that.
Well, I think that in your first, but I mean,
law that do involve very slight touchings that only a person of special, I mean, the eggshell plaintiff you mentioned, for example. Well, most people, you might not know a person as an eggshell plaintiff, but what if you do? What if a person has a very serious injury to the arm, and a mere touch will cause that harm.
So again, my answer is that the American Law Institute, when considering whether that was a valid way of describing tort law, said that is not a valid way of describing tort law. And tort law, unlike criminal law, is a common law development. And so to the extent that the American Law Institute spent a couple of years studying the development of tort law and said, we don't think there is support for this notion that your butterfly example is an offensive touching, then I think that answers the question, that if it were so clear at the common law, then I think the American Law Institute would have said it is part of the common law.
Well, and
But
hasn't our legislature already dealt with the situation where the person is actually injured? I mean, if you know
I'm
that,
sorry?
where the person is actually seriously injured,
Yes,
right?
absolutely,
I mean,
felony
so we've
assault.
got felony assault and
Exactly.
aggravated assault. So if
Absolutely.
you know that someone's a hemophiliac and you give them a paper cut, they can be prosecuted
Absolutely.
under felony assault or aggravated assault.
And do you think simple assault is a lesser included offense of aggravated assault by its elements?
Of aggravated assault. So aggravated assault requires a, if I can remember the language, conscious disregard of.
It's a somewhat convoluted statute.
Yeah,
It's hard
I
to remember all
kind
its
of don't.
permutations.
So I think that to the extent, but aggravated assault requires a conscious disregard of, I think it's serious bodily injury, right? It's not just any injury.
Yes.
Right. And so I think that that is consistent with the common law treating the reckless use of dangerous weapons that involve a risk of serious bodily injury as sort of a substitute for intent to injure. And so, I would draw the analogy to this
I'm not sure
court's en banc.
I'm not sure whether I've gotten a definite answer of
Okay.
whether you think by its elements, common law simple assault in DC is a lesser included offense of statutory aggravated
I
assault.
think so.
And the same with second degree murder?
Yes, second degree murder, yes.
And so, although you have said perhaps, it seems if that's what you believe, then it must be true that sometimes you can commit an assault where you do not intend or even know that you will injure somebody. Because
Yes,
if
with
you
a
have,
dangerous-
if you have, malice, conscious disregard of a known and substantial risk of death or serious bodily injury, the form of malice, the most relevant to this discussion, I think, doesn't require use of a weapon, although it often would be accompanied by it.
Right.
So do you more generally agree that any time the defendant's mens rea is conscious disregard of a substantial risk of death or serious bodily injury, whether a weapon is involved or not, that mens rea is sufficient for common law simple assault?
I'm not sure about that because I haven't seen cases that involve that degree of mens rea without a weapon. So
I think it means then you're not sure about whether simple assault is by its elements a lesser included offense of second-degree murder.
you might be right. I think that this, so I
Does it
have
matter-
not looked to see if the, I mean, all of the government's cases that talk about recklessness involve weapons. And so those are that, I think that's an easier case where weapons are something that it would make sense for the common law to say, we want to regulate weapons because they are extremely dangerous, and we want to sort of draw a wide circle around their use and say, if it's going to be reckless use, that's a crime.
Does it matter if we're talking about simple assault, not ADW? Does it matter if the assault is an actual completed battery versus an actual inchoate offense?
So,
Right? I mean, do we have any cases where we have an actual inchoate battery as opposed to a failed battery or a completed battery by an unwanted touching?
So is your question, does the mens rea differ depending on whether it's
Correct.
an assault, an attempt versus a battery?
Right, an actual attempt.
Right. So the common law authorities say that every battery includes an assault, which would suggest that the mens rea should be the same, which would also suggest that since an attempt requires an intent to injure, that a battery should also require an attempt to injure. Now, I do think there have been some commentators that have suggested that the mens rea could be, perhaps should be as a matter of policy different, depending on whether the injury results, and that's actually how the Model Penal Code does it. So the Model Penal Code says an assault is an attempt to injure, which I think would include an intention to injure, or purposely, knowingly, or recklessly causing bodily injury. So the Model Penal Code bifurcates that. I think it would be reasonable for a legislature to do that. I'm not sure that it's that clear in the common law whether there is that bifurcation, but I think that the common law absolutely, when sort of the well-established bedrock meaning of assault includes an intention to injure.
When you ask us to look at the common law, what common law are you asking us to look at?
I'm looking at, well, this court has said that the District of Columbia's common law is the common law of Maryland in 1801. And I've looked for such cases in Maryland, and they don't really exist that really discuss this issue. So I think that the common law is, when Congress would use the word assault, that had a common law meaning. And that it would include English common law that the American colonists brought over, and early American common law that existed at the time of 1901. That's what Congress was thinking of when it said the word assault. That's the type of statutory interpretation that the Supreme Court has.
And if we hypothesize that Congress was thinking about that and canvassing the common law cases
Right.
at the time,
Right.
what cases would you point us to where a court said this was an unwanted touching, the defendant was informed that the touching was unwanted, but nonetheless it does not constitute assault because it wasn't aggravated enough or didn't cause shame or
Right.
humiliation? What dots on the map would Congress have seen to say, well, of course, we couldn't have intended that to be assault?
So Coward versus Badley is one. Coward versus Badley is an English case from 1859 that was widely cited in American law treatises, and it's discussed in our brief. That case, the touching was, I think, obviously unwanted. It was a stranger who came up to another person and said, hey, you're spraying water on this burning building, you're doing it wrong, you're just spreading the flames. He said it multiple times, and the person said, go away, mind your own business. And nonetheless, so I think that person is basically, he didn't say in so many words, don't touch me, but he's saying, go away, mind your own business. And the person nonetheless touches him on the shoulder and directs the stream of water away from the building. The court said that was not a criminal assault because there was no intention. The jury actually found that the intent was to attract his attention, and it was not a hostile intention.
Although that's more focused on the mens rea part of the
So,
discussion, rather
yes,
than, my
and
question
Coward versus
happened to be focused more on the actus reus, although you're,
Okay. But actually, Coward versus Badley was then cited in, I believe it's actually the government, one of the treatises or law review articles. I think it's the Rawlinson Law Review article that the government cites as an example of a type of touching that is not offensive to a person of reasonable sensibility. That's the Rawlinson
I
article.
don't think that touching was offensive even to this person who was touched. It wasn't the touching that was offensive in that case. It was just being bothered by somebody who's interfering with his firefighting.
Oh, no, the person was extremely offended. He, in fact, thought it was an assault and gave that person to a police officer and said, this person has just assaulted
Right,
me.
but what I meant was that it wasn't that right, he claimed it was an assault. But the reason it was an assault in that case was not that this person has a special sensitivity to this kind of touching and told the person, don't touch me. There was none of that. This was an assault because the slightest touch can constitute an assault.
But the court said it wasn't an assault.
Right, and that for intentional reasons, but not because the person had a unique sensitivity or didn't have a unique sensitivity or.
Well, I guess I was just explaining that commentators have treated that case, the Rawlinson article treated Coward versus Badley as not only informative about an intention to injure as an essential element, but also that was not the type of touching that would be offensive to a person of reasonable sensibility.
Do you think it strains credulity to think that Congress was aware of this 1859 English case and law review article that put a gloss on it?
Well, not the law review article because it came after 1901, but it definitely was. I think you would have to presume that it was aware of this case because it was a widely cited case in many, many treatises for the very proposition that an intent to injure is essential. We cite those cases in our brief. those treatises in our brief.
What do you make of the Boisson case? Justice Kagan wrote an opinion about the mens rea of
Yes.
common law battery, and she looked at the materials and drew a conclusion that seems somewhat different from the one you're advocating. The conclusion she seems to draw was, it was anybody's guess, there were confusing strands. There's this language about general intent, and who knows what
Right.
that means, and it seems less than what you're suggesting is clearly established. So do you think Justice Kagan was just incorrect in her understanding of the common law?
No, I think Justice Kagan didn't have many of the authorities that we cited in our brief, in the briefing before her. But I do also think that she did have many of the cases the government cites. The United States filed a brief in Boisson, that all of the reckless use of guns cases were in the government's brief. And what she concluded was that it is very unclear, virtually impossible to tell whether recklessness was a concept sufficient to establish assault at common law. And I think that answers the question for this court, because if there's ambiguity, then number one, the Congress could not have intended to incorporate a recklessness standard if it was unclear in the common law whether recklessness
Are we
existed.
frozen in time, really, and constrained only to the late 1800s in terms of early 1900s, in terms of what common law we can consider? What about all of our cases in this jurisdiction since that time? We have to disregard those? We can't revisit? We're not bound by, I know we're sitting as an en banc
Right.
court, but what do we do with all of our case law that has developed since the
I
common
think
law
this court's
time?
case law is generally consistent, at least in its results. And, you know, as Judge Ruiz pointed out in her concurrence in Buchanan, all of these cases about general intent involved dangerous weapons. And so I think, and all of the ones that involve things like spitting and sexual assault, the intent is really pretty obvious in those cases. So I don't think this court needed
What about the Harris
to.
case where there
sorry?
was, what about the Harris case where we found it was a simple assault to jostle somebody?
That was in the course of a robbery. And I think that a stranger touching you for the purpose of a robbery, I think, could inspire fear, shame, humiliation, or mental anguish.
So are you asking us to clarify our case, any of our cases to this point?
I think that this court got it right in Williams and in Buchanan when it said that the essence of the offense is the intentional infliction of injury. And I think that there has been some confusing language in this court's case law arising from the use of the word general intent. I think general intent, if you look at those cases actually, the cases that talk about general intent cite other cases that say things like, assault does not require an intent to inflict the specific and particular injury that was actually inflicted. It could be a different victim. Maybe you intended one victim and actually injured another. That's like the Cowley case that the government cites.
So if you
Maybe
could give us the language that you would say clarifies any confusion in Williams, Buchanan, and clearly states what the common law is for simple assault, what would you say?
Yes, I think that the language would be that an assault requires an intention or purpose to inflict bodily injury. Bodily injury being defined as harmful or offensive contact. Offensive contact being defined as a contact that would induce fear, shame, humiliation, or mental anguish in a person of reasonable sensibility.
An intent could be inferred.
An intent can be inferred
the act.
from all of the circumstances, including the natural and probable consequences of the act itself. That's an instruction that is already in the Red Book that this court approved in Wilson Bay, including from reckless conduct, including from the person's knowledge. Those are all things that evidence that a fact finder could infer purpose or intention from.
Thank you. I see we've used your
Yes.
time, but you have reserved some time for rebuttal.
Thank you very much.
Morning, Your Honors. May it please the Court, my name is Chris Ellen Kolb. I represent the United States in this matter. Your Honor, parties may disagree on the outcome and the resolution of the defendant's particular case here on its facts, but the parties actually aren't that far apart on the doctrinal issues that the Court has asked us to address with respect to the elements of simple assault. Let me first address where I think we have some general agreement, and then I will address some of the issues that the court has discussed with my opposing counsel. First, with respect to what we think are some general areas of agreement. The parties agree that properly understood, simple assault includes an offensive, non-sexual touching. The parties agree that an offensive touching is an unwanted contact that objectively offends a person's reasonable sense of personal dignity under the totality of the circumstances. And third, the parties agree that to the extent the court has used a formulation of general intent to describe the mens rea for simple assault, that has proved confusing, and that we need some type of refinement in how the court addresses the intent requirement for assault. Now, how we get from there to the result in this case is where I think the rubber meets the road. But first, let me address, if I may, the offensive touching question. The common law, I think, makes clear that every man's person is sacred, and the court in Bousselet said there is a right to be let alone. Even the slightest offensive touching may be covered by the common law of simple assault. Now, the key here is whether the conduct offends a reasonable sense of personal dignity under the totality of the circumstances, tied to the bodily integrity of the individual in question. And that totality of the circumstances, and this is where I think there's some disagreement here between the government and the defendant, that totality of the circumstances does include the victim and what we know about the victim, the circumstances of what a defendant knows about the victim. So in this case, Your Honor, when you have a victim who expressly and unequivocally says, I don't want to be touched, as the trial court found here, not only is that a subjective offense, but objectively, as the trial court found below, a reasonable person, a person of reasonable sensibility would find that a second touch would be offensive to sense of personal dignity.
So I ride the metro, and rush hour gets pretty crowded, and I don't like that. So I get a T-shirt printed up that says, "Don't touch me or I'll punch you." And I wear it on the metro every day. If someone makes contact with me, have I been assaulted?
It would depend on the totality of the circumstances. For example, if
So
it's a
my
crowded car,
circumstances in my hypothetical are I'm riding the metro at rush hour, Monday through Friday, and wearing my T-shirt. So it's crowded, there are people on the train with me. Do I have the right to demand that they make zero contact with me? And if they do, I have been assaulted and I can call the police.
well, it's a reasonable sense of personal dignity, dependent on the circumstances. So if it's a crowded metro car, I think there would be an argument that would not be a reasonable sense of personal dignity. If it were not a crowded metro
Sorry,
car.
just to make clear though, my T-shirt is a request. And I understood that the government's argument was by requesting that someone not touch you, then the next touch is unreasonable and offensive.
Not in all cases, Judge. I think that's a little bit too broad a brush. I think it's a question of, it's an intentional touching, number one, and it's also a touching which at least would be, there would be a risk of offending that would be very much a conscious disregard of an unjustifiable risk. Now, that unjustifiable risk, as the court has formulated that standard of intent, it wouldn't be unjustifiable if I'm just in the metro car and it's really crowded. It would be a problem, however, if it weren't a crowded car, I see your T-shirt and I say, who does that lady think she is? And I go up and I give you a poke. I'd say that's a simple assault. And that's the difference here. And that's where I think the totality of the circumstances is something that the court should consider. Let me also address in terms of the totality of the circumstances. Appellant has suggested that the government's test is a wholly subjective one and that it's not a meaningful test. We disagree. And the reason we disagree is that that's the beauty of the common law. It's inherent in the common law.
Can you clarify, just at this juncture, you're talking about actus reus?
Yes, Your Honor.
Because there's a point at which the actus reus and the mens rea bleed together when we're talking about subjective, objective.
That's right.
You're talking about objective in the sense of whether the touching, the actus reus, is offensive. Okay.
So, and I don't think the government's position is that any unwanted touching under any circumstance is a crime. That's not our position. Our position is based on the totality of the circumstances. And what I
Does
believe,
that get at knowledge? Knowledge?
yes.
If you know something particular about the person.
That is part of the totality of the circumstances. And I guess the best example I can give of that would be the cases that the court has decided in the threats context. And an example would be in Ray SW, where the court there looked at whether or not a particular comment was threatening based on the relations of the parties and what the parties knew about each other at the time.
Can I ask you, does your objectively reasonable offensive contact test, taking into account the totality of the circumstances, if you leave out that totality of the circumstances piece, which I'm not sure whether appellant agrees with that or not, although it's not clear. Does that change the outcome of this case here, the facts of this case, if we just are looking at objectively reasonably offensive contact versus objectively reasonable offensive contact under the particular circumstances and taking into account this particular complaining witness, do we get a different result, or is the result the same when we look at this case?
Well, I want to say three things about that. First, I believe, at least my reading of appellant's brief at page 14 of their brief, the appellant does address and consider also in their test the totality of the circumstances. So I think there's really nobody here thinks that we could divorce the assault from the totality of the circumstances. Second, I would say, and this goes back to the point I wanted to make about the common law, our jurisdiction as a common law jurisdiction only uses the term assault in the statute, which has a common law meaning, and it's freighted with all of these cases that have a lot of moss on them for sure. But the point of the common law is that it is an evolving doctrine, and it allows judge-made law precisely on the facts and circumstances of individual cases. That's what this court said, for example, in the manslaughter context. There's a case, Robert Williams, which cites an old DC Circuit case, Lincoln's, exactly for that proposition. That's the point of the common law.
We're not trapped back in 1901.
No, we do not believe the court is trapped. I did want to address one of the concerns raised by Judge Easterly, which is, why are we criminalizing, if you will, someone just being irritated? And how does that relate to the common law? We submit, Your Honor, that this court, as well in Anthony, as well as some of the language in the fourth commentary of Blackstone, addresses that point. And the point of simple assault and protecting against invasions of the right to personal dignity is to protect against the tendency towards resistance or conflict. And if we look at this case, as crazy as the facts are, we did have resistance and conflict. And so really, it's not just a question of saying, oh, this is a de minimis contact, who cares? Well, that's not the government's position. And I think I understand Your Honor's concern that we don't want to criminalize everything under the sun. However, we're talking here about, as a general principle, what would constitute an offensive contact and what is the common law trying to address? And we think that the tendency towards resistance and conflict is why this would constitute an offense on these facts. And let me also
Your
say—
opponent argues that, and this is, I think, an area of disagreement, when you formulate the nature of the offensive touching, you talk about offending a sense of personal dignity, and you don't use the adjectives like anguish, shame, humiliation, and fear. Do you agree or disagree that that formulation is an accurate statement of what the measure or metric is of how offensive a touching has to be in order to qualify to be an assault under the common law?
Your Honor, this court has used that formulation, as my opponent correctly noted, in Bousselet, and we've cited that also. But my point on that is this. I think that the underlying touchstone is whether or not the contact would have this tendency towards resistance and conflict. And if someone makes you fearful, someone makes you ashamed, someone is intentionally trying to provoke you, that might be an assault. And that's what I think that's what we had in this case, and that's what the trial court found in this case, potentially.
Go back to my T-shirt example. It seems to me that the government's view of this then is that everyone is privileged to wear my T-shirt, right? Multiply my T-shirt by the population of the District of Columbia, and we can all walk around with T-shirts that say, "Don't touch me or I'll punch you." Doesn't that create more conflict than the converse, right?
Well-
Which is, chill out, this isn't a crime, right? This offended you and it irritated you and it's annoying, but it seems to me that the government's view would make high crime areas out of every playground in the district, right? I mean, because if you want to hear "don't touch me" and "stop it," you'll hear that 100 times a day in those localities.
Right. And in the common law, the case that we cite in our brief, Cole versus Turner, I think addresses kind of the big picture there, which is you have to look at where you are when you're wearing that T-shirt. So if I'm wearing that T-shirt and just walking down the street, okay, fine. But if someone, as I said, comes up to me, seeing my T-shirt, knowing I don't want to be touched, and intentionally touches me, that's different. So Cole versus Turner gives the example of if you're in a narrow passage and there's no way to avoid touching someone who might not even want to be touched, that's not necessarily an assault. But if I jostle my way through that narrow passage, knowing it's a narrow passage and knowing you're standing right there, well, Cole versus Turner suggests that might be an assault. And the point, I guess, Judge, is, we could spin out 1,000 million hypotheticals, but the common law, and that's why I think actually the district's, for all of its warts, the district's assault statute has value because it does allow us to address all the different permutations. So there may be permutations of Your Honor's example that are simple assaults, and there may be others that aren't.
What about,
But aren't
I was
we-
interested in Judge Easterly's playground example, and I'm just wondering whether, I do think it's consistent with my recollection as a parent that you would hear, children don't always behave that well, and they're out, getting their yayas out, and some of them start touching each other in ways that they don't like, and people start yelling. And is it your view that in theory, there are, juvenile respondents on every playground because they're committing simple assaults? Or does age somehow factor into it? Or
Age could factor into it, I think. And again, the totality of the circumstances, you're on a playground, things are going to get wild and woolly, and you're out there and your children are out there. I think that informs what would be your reasonable expectation of personal dignity.
Are you viewing that as a form of consent then?
In some senses, and there are some cases that say there's an implied consent. And there is sometimes an implied consent in social interaction, and that's something that the common law has recognized. So the other point that I guess I
just
wanted.
before you, I'm sorry, Mary.
Yes, Your Honor.
I'd like to ask you something about what you're saying about the approach to the common law. Because one thing that concerns me a bit is whether it is appropriate, indeed whether it's constitutionally appropriate, to take a look at the common law definition of assaults and in effect expand it beyond what it was at the common law, which raises questions, I think, or potentially raises questions of notice, due process, and the like. What's your response to that?
I have
Because
two-
I think at bottom,
Right.
what appellant is arguing is that however meritorious the position might be, that, for example, recklessness applies or what have you, we'd be expanding the common law to adopt that position.
Well, I have three things I want to say. Number one, we don't think that our position is an expansion of the common law. We think that this is wholly consistent with the common law, both in terms of the actus reus and the mens rea. But two, assume arguendo that that's not clearly established in the common law. Is there, I guess the court's asking, some type of due process or rule of lenity or other kinds of concerns? And we believe no. And the reason is, first, the rule of lenity and that general concept doesn't really, first of all, rule of lenity doesn't really apply to common law. And although this court hasn't said that, the Maryland courts have.
But it applies to statutes that are codifying the common law.
Correct. And Your Honor,
That's what we're doing here.
I agree, but the Maryland courts that at least I could find, there's a case called Pair, P-A-I-R, that discusses exactly this question, that because a statute uses the word assault doesn't mean that somehow the rule of lenity is invoked, and if there's never been a case on the point, that the defendant and the defendant's view of the law wins. The third point I guess I wanted to make, Your Honor, in response to your question, is the whole point of the common law is that we have general principles that we apply to particular facts and circumstances presented to the court. And the court actually wrestled with this issue in its recent case of Tan. And in footnote 35 of that opinion, the court says, look, we understand there's not a case directly on point, but our job as judges, and why we get paid the big bucks, is to figure out what the law is and apply it under the facts and circumstances of this case. So here, we submit that there is no real tension in the common law, and we think a defendant, knowing that there's an assault statute on the books, right, that statute can be applied based on the facts and circumstances of the case. That's what the legislature intends, and that's what this court is here to do, to enforce.
Ms. Kolb, this may be an inevitable product of the common law approach that you are touting, but one of the reasons our case law about assault is in such disarray is because over more than a century, judges have addressed the totality of the circumstances, said things that they thought made sense in that case, and then when you look back on them globally, it's a mess.
Well, Your Honor, I wouldn't want to cast aspersions on judges as a general rule, but I think that the point, I think, for common law is that we do have general principles. And what I was trying to do in the government's brief, at least in part, is explain that the way that this court has articulated simple assault actually does have roots in the common law. The point is, and I actually agree with appellant and with Judge Ruiz's concurrence, in Buchanan on this point. It's when we get these hard cases, these unusual cases, that sometimes the court has difficulty in hewing to these old common law formulations. But that doesn't mean, I think, that the court has made a complete mess of it. It just means that this is the type of doctrine that requires careful attention on a case-by-case basis, and we do think there are general principles that we can distill from this court's cases.
So why can't one of the general principles be that whatever assault is, whatever offensiveness is, it's not mere annoyance, right? I mean, the Cole versus Turner example, it exemplifies that, right? It's not just, oh, I got bumped and I didn't want to be bumped. Too bad, right? That's life. Sometimes you get bumped. Or the Hale case that I can't remember whether you or
The appellant's relying on the Hale case.
cited, right? Where, this woman is walking out with her new beau and the old beau, or maybe the once and future beau, comes up and talks to her or touches her. Maybe that was annoying at the time. I guess they got back together, but that's not assault, right? Why can't we discern from, I'm not seeing in the common law cases anything akin to what we have here. And if we're trying to figure out how low can you go, why can't we say this is just not offensiveness within the meaning of the common law as far as we can see?
Well, we would disagree with that. And because the common law, in our view, protects the right to personal integrity. And so the fact that something invades your right to personal integrity, whether you call it annoying, whether you call it offensive, whether it places you in fear, or whether it provokes you, all of those things are protected in our view. And I think that's consistent with the common law. I agree, Your Honor, that I can't come up and have 15 cases with this fact pattern. There aren't. The closest one, or the one that I thought that was the most interesting, was the Eichenwald versus Ravello case, which was a civil case and is actually a parallel criminal case where an individual sent a microblog email to a reporter knowing that the reporter had epilepsy. And ironically, that individual pled guilty to assault in Texas yesterday. But that's the kind of thing where just sending a microblog, if I send an email, generally speaking, that's not assaultive, but I'm informed with the totality of the circumstances, I know that this is likely to cause some serious harm to this individual because his epilepsy, he's written about, it's in the public domain. And so, again, I don't think that these lend themselves to hard and fast rules, but we do think that the right to bodily integrity is something that the common law protects. And I guess the final thing I want to say on this point before I move to mens rea is, for sure, this is an unusual case. And I think I'm fairly confident in saying that we're not going to see the floodgates open of poke and touch cases in the Superior Court. But we're here to vindicate the general principle of what the common law is and what that protects. And the actus reus here, we believe, is to include an offensive touching, which would focus on whether or not the contact is offensive to a person's reasonable sense of personal dignity under the totality of the circumstances. That includes, among many factors, age, relations of the parties, and known sensitivities of the victim. Now,
But before we turn to mens rea, just really quick, do we need to examine what the actual inchoate offense of assault is? Do we need to define that actus reus, what that looks like? Right? I mean, we have cases where there's the completed battery, and we have cases that I would describe as sort of the failed battery, right? The bullet whizzing by the head, right? But do we need to, if we're explicating what assault is, right? Assault is technically the inchoate offense. Do we need to say what that act looks like and what the boundaries of that act are?
well, I think I actually agree with appellant here that the attempted battery, the completed battery, and the intent to frighten type of battery, I think all of those, and the use of the word attempt is really more of a term of art. But we're looking at the conduct, and we're looking at the conduct to the extent it affects the reasonable sense of personal dignity of the person who is subject to that conduct. And I think that test applies across all variants of simple assault. So I don't think the court would have to go into a granular level of detail to set forth what the actus reus of simple assault is.
I mean, my concern is, say, with Judge Fisher's wet willy example, right? I wet my finger, I hold it up in the air. Maybe I'm trying to see which way the wind is blowing. Maybe I'm trying to put it in someone's ear, right? How far do I have to get in the inchoate offense to get an assault charge?
Something that would cause an offense to or the likelihood of touching, of an unwanted touching in that situation. So if you were just holding it up here in the courtroom, probably by definition it wouldn't come close. But that's exactly why the fact finder would have to decide. If you had your wet finger and came up to my face, that might be a closer call. But again, I think that the beauty of the common law and the totality of the circumstances is exactly to address these fine layers of distinction that really, frankly, don't lend themselves to a hard and fast rule. And ironically, the restatement of torts, we cited the third version, and then after our version, they came out with another version in October 2019, which appellant's relying on. And the ALI is trying to distill what are the overarching principles of tort law and all the rest, is having difficulty articulating a hard and fast rule on these types of scenarios. But the one thing that both versions of the restatement, whether the June 2019 version or the October 2019 version say, I think, is that at some level, the particular circumstances, even as to a sensitive victim, would matter. Now, how we're going to refine that, and if we can articulate a hard and fast rule, the ALI is still duking it out on that question, but I don't think that the ALI has disavowed that that is a relevant circumstance.
Is it possible to have an attempted assault?
That's an interesting question, and there have been like 3 or 4 law review articles written about that. I think there's a dispute about that question among the commentators. But I think, at least to me, the view that made the most sense was the article by Professor Dressler, who talks about how assault is almost sui generis and developed a common law long before the idea of attempt law, and that it's really somewhat apples and oranges to try to say that you could have an attempt and an assault and that those two ideas don't mesh. So
if the attempt aspect of assault is not, or is it coextensive with our attempt concepts?
no, I don't think it is. I
What
think
is
it's a
it?
different animal.
What is it?
The attempt aspect of assault, and I think the commentators have talked about this, is whether or not the conduct comes close to the extent it starts to approach the level at which it would portend some type of injury or offense.
Like, I think there was one of you guys cited a California case that had some language, something
Yes.
about you can tell the next thing that would
That's
happen.
right.
Do
That's
you
the
agree with
Williams
that?
case.
Okay.
We cited that. And I think that Williams case from the California Supreme Court is helpful because it kind of tries to explain that attempt and attempts in the context of assaults are kind of hard to reconcile. So I know that the court has somewhat, has noted that doctrinal difficulty. But I don't think that the court really should view assaults within the lens of typical attempts. I think it's a different animal.
Could I ask you about this? Because maybe you think I'm thinking about this incorrectly. I think of the offense of assault as encompassing, in effect, two types of completed offense, one of them being battery and the other being, call it, the word used in the statute begins with an M.
Menacing threat?
Yes,
Right.
and menacing. And in addition, it encompasses attempts to commit a battery or attempt to commit a menacing. That's how I've thought of it. And from that perspective, I've thought, okay, and then, now there are issues about what attempt, how to define attempt, but I don't think those issues are the ones that are raised in this case, and I don't think we have to deal with them. I guess, is what I've just said consistent with what you've been saying about attempted in the assault context being different from attempt
I
conceived
think it
of
is
generally?
because it's sometimes you've seen the cases talk about an attempt to inflict physical injury or corporeal injury, right? And I think the attempt to inflict corporeal injury is not so much, or at least my understanding is it's not the same type of, say, an attempt under an attempt statute. Is my conduct close to inflicting an injury on another person in terms of the totality of the circumstances such that it would likely produce fear or injury or tendency towards resistance or offense? That, I think, is the way I view attempt as it's been used in the common law as the attempt to inflict corporeal or other injury on another.
And you think that might be a different concept of attempt from
Yes.
attempts generally?
Yes, I do.
But, I mean, at least in Ray, we seemed to think that assault as an attempt was within the category of attempts generally. I mean, we have a passage where we talk about, assault, the attempted battery type of assault is just another kind of attempted crime. And we're citing Fleming and the proposition, a DC Circuit case from 1966, that a person charged with an attempt to commit a crime may be convicted even though the evidence shows a completed offense, not simply, I mean, we seem to be.
Right, but that's for a different, I think that's for a different proposition, which is that a completed battery could be an assault. And that's all the court was addressing there. I don't think that the court in Ray was suggesting that attempt for purposes of simple assault is necessarily, and in all cases, the same as an attempt in other contexts. And I think the other cases, and certainly the common law cases, make that clear. They're not mutually exclusive, don't get me wrong. There can be some overlap. I'm not suggesting they're mutually exclusive, I'm just saying it's not a perfect overlap, and that it's a little bit different in the assault context.
Ms. Kolb, if you won't let me use the phrase general intent anymore, how should we define mens rea?
Well, Your Honor, the government's proposal here is that the court basically follow what the court has already done, or something similar to what the court did in Carrell, which is to use the model penal code's hierarchy of mental states in order to basically help inform a jury's assessment of what the mens rea should be.
A penal code, by definition, is not part of the common law tradition.
Well, Your Honor, I actually don't know if I would agree with that. Certainly, the model penal code was written in the 1960s. I agree it wasn't in existence at the time the statute was passed. But I think there is case law, and Alonis itself actually talks about this. is that the point of the common law is to have the state of mind to be such that you can differentiate between wrongful conduct and innocent conduct, and that is sometimes more easily expressed in terms of the gradations of wrongful or bad mind, if you will. So I think that the question, though, is, and courts, I mean, we've cited in our brief at 23, there are a lot of federal courts that have said that when there's a general intent crime, that we presume that these are the general states of mind that's consistent with purpose, knowledge, or recklessness.
I mean, the court in Alanis didn't think that it was substituting the model penal code for the common law understanding. It was just swapping out terms because it thought that they were more clear, right?
Absolutely, and that's what the court did in Carroll as well, and that's what the government's asking the court to do here. I think it would avoid the confusion, and I think the court's already taken this path in Carroll.
Talk to
Although
us
not as
about
far as you would like
recklessness
us.
a little bit. Oh, I'm sorry.
Oh, go ahead.
You, in Carroll, we stopped short of adopting the recklessness prong. We did purposefully, knowingly, and we didn't incorporate recklessly. And the cases that the government cites, as appellant has pointed out, all involve a dangerous weapon when we talk about recklessness. And I've been struggling to try to figure out what a reckless simple assault looks like
Okay, well,
without a weapon.
let me unpack, I think, Your Honor's question. I would like to say three things. First, we think that with respect to Carrell and even Alonis, we agree they don't address, or don't adopt, I should say, recklessness as the standard. And there's a reason for that. The reason is that in the Supreme Court, as the Supreme Court said in its own opinion, recklessness wasn't really fully presented, and the court, as a prudential matter, didn't want to address it. And in the Carroll case, the government in its briefs said to the court, we don't anticipating relying on a recklessness theory for threats, and so the court didn't really need to reach it either. And so the fact that the court didn't address recklessness in either Alonis or Carroll, we don't think really should be dispositive or determinative here. Now, I think the second point I wanted to make, Your Honor, is in terms of recklessness generally. I don't agree that recklessness is only in the common law cases when dangerous weapons, guns are available. Granted, there's a ton
Are there any
of.
simple assault recklessness?
Well,
cases?
I tried to find some simple assault cases that we cited in our brief, and there are a few others that I didn't cite in the brief. But anyway, the one I thought there are a few that are helpful. One is the Hill case, which is the old Georgia case where the boys are on the playground throwing rocks at each other, and appellant argues, well, it was throwing a rock at someone, and so therefore it was a specific intent purpose. No, that's not the way the court resolved that case. The court resolved that case in Georgia saying that the boy, the defendant in that case, was making the boy the object of his throw. He thought the boy would duck, which is what the game or whatever they had been doing had happened, and the court quite clearly said that under those circumstances, the defendant, the young boy, was responsible for his wanton and reckless conduct. So that's
Can't the rock be the weapon in that case?
for sure. It could be, but it's certainly not a gun. And the other case, I guess, Your Honor, that's not a gun case would be Stratton, which is the love powders case. The love powders are.
I never did figure out what a love powder was.
I think it's cantharides or something. I don't quite know what it is, but I hope I never have to try them. The love powders case, which is a Massachusetts case, the defendant there, he knew, or at least he had been assured, let me put it this way. He had been assured that they were not deleterious to human health. He knew that they weren't ordinary food. He wanted to, and the opinion says, try the effect on her. And so he put it in the figs. The woman eats the figs and gets sick. The court there said that, even though he was ignorant of the actual likely result, there was still a simple assault in that case because he took the risk.
Each of those cases, there was risk of or actually physical injury in the more traditional sense. rather than, I don't want to use the word mere, or I will, but a mere offensive touching that wasn't going to be physically injurious, but instead would really be more offensive to a sense of personal dignity. Are there cases that go so far as to find a defendant criminally liable for an offensive touching, not physically injurious, not presaging possible physical injury, but merely because it would be offensive to a sense of personal dignity, and where the defendant's state of mind was neither knowledge nor purpose, but instead a conscious disregard of a known and substantial risk of offense?
Judge, I haven't found a case on all fours with that factual
And can I ask you,
scenario.
and relatedly, your opponent argues that if you, as you seem to think is more appropriate than your opponent does, look at modern statutory law, that really only in Maine could you find a legislature that has chosen to go as far as to criminalize conduct that was reckless as to the possibility of a merely offensive touching. Is that accurate?
Well, I believe that as far as statutory law, that's accurate, but as I think the questioning indicated earlier, the existence of statutory law in other jurisdictions is irrelevant here because we're a common law jurisdiction.
Well, if your view is that part of the genius of the common law is for this court to look around now and figure out what makes sense in the evolution of the common law, then I think on your view, contrary to your opponent's view of what we should be doing, but on your view of what we should be doing, I would think that that law would be quite germane. Let me just ask you a hypothetical too. So imagine person A and person B go on a date, first date. And person A is at the end of the date thinking, well, I'm considering whether to kiss person B, and is hoping that it will be received well. Doesn't intend that it won't be, doesn't know that it won't be, but realizes, I don't really know. I think it's quite possible that I'm going a little too fast here, and person B might not like it. And so person A tries to kiss person B, and person B is like, what are you doing? This is horrible. And let's assume for a moment that an unwanted touching would be, an unwanted kiss on the lips, let's say, would be sufficiently injurious to be the actus reus. Wouldn't, on your view, that be a crime because the complainant, the defendant, would have consciously disregarded, didn't intend offense, didn't know there was going to be offense, but consciously disregarded a known and substantial risk that there might be, hoped there wouldn't be, but it's possible, might not be. On your
I
view,
think it depends
is that a crime?
on social customs and what the known and substantial risks would be.
So what's
right.
crime or no crime? This is what we, we have the knowledge that we have of our social
That's a hard
customs, so-
case, and I know that the restatement had an example where the woman was known to have had, a very strict upbringing. That would be different. But if it would really depend on the community that you're in and what the expectations would be. It could be an assault depending on the totality of the circumstances. I don't disagree. But, again, that would be a hard case. But let me address.
I guess I was thinking that maybe it would be an easy case that it's not a crime, and that you would have some
It
rationale
would
about
depend
why
on
it
the
wouldn't be,
community
but,
that you're in, really. I mean, if you were in a community where, there was some understanding that, I'm trying to think that TV show that my daughters watch that I can't stand, the Duggars, and they have all these really weird rules about, courting and all this. I mean, there are people who have that. And so if you're in that kind of a community, that could be an assault, is all I'm
How
saying.
does that protect the public? I mean, this standard sounds very wishy-washy.
Well, it protects
How do people know what is expected, how to comport themselves in a non-criminal
Right.
way
And
with all this fuzzy?
that's why this is a difficult hypothetical question, because it would be the question of how substantial is the risk of it being offensive. In everyday accordance, the daily concourse of life, it probably wouldn't be a substantial risk that it would be highly offensive. It probably wouldn't be. But
is your standard highly offensive or offensive?
well,
I'm just asking you.
Right.
I'm just curious because you were using the word highly offensive,
well,
and I wasn't
it's
sure that
for
that's
recklessness purposes, and I should clarify that. It's a substantial and unjustifiable risk. That's the standard that I'm using, of
With
offense,
respect-
of
of
offense.
offense,
So
not
an
high offense.
unjustifiable risk, I think, would build into some of that. But I agree, I don't think it has to be necessarily highly offensive. Your Honor, if I could, in terms of recklessness.
I'm sorry, one more thing. This is to wrap around to this case before I forget. Assume that we agreed with you that purpose or knowledge are not required, and that conscious disregard of a known and substantial risk of offense, objective, appropriately defined as a person of reasonable sensibility, is required, would we need to remand? Because I don't see that the trial court made any such finding. In fact, what the trial court said about mens rea was, and understandably in light of the things we've said in our cases, so I don't really fault the trial court here, but the trial court said, I'm not going to get into the question of whether there was intended offense. I don't have to get into that. All that I think is required is that the defendant intended to do the act that gave offense.
Right.
And
The
that
judge
seems like
did
that isn't
say,
recklessness.
right, the judge did say that, and I would agree that that kind of makes the record here somewhat opaque, and we wouldn't be averse to a remand if, depending on how the court articulates the elements here. I do think, though, that if you look at the record, you do have findings that this was an intentional contact, that it was known to be offensive, and that the defendant made that contact. So I think under a recklessness theory, you could affirm, but I want to go back to, if I could, why recklessness should be an accepted state of mind for simple assault. We do believe the common law cases embrace it. We'd also note that in Voisin, even though the Supreme Court kind of said, well, we don't know where recklessness stands, the Supreme Court in Voisin did say that from the mid-1800s, recklessness did start to appear in the course of common law jurisprudence, and that's very relevant for when the District of Columbia Code was written in 1901. Also, I think in terms of recklessness and wrongfulness, I think the court has decided in many other scenarios that in terms of recklessness, it is a conscious disregard by the defendant of a known and substantial risk of injury. That's blameworthy behavior. It's not the same, and we think it's very different from what appellant is proposing. It's not the same as saying, I really hope I hurt you, and I'm going to do whatever I can to hurt you. That's purposeful. That's the conscious desire to injure or purpose that appellant is proposing. That's
Actually, when you use the word injure in there, you mean more
offend,
precisely
yes.
offend.
I'm using injure as an umbrella term, Your Honor. Okay, just to move it along. But in terms of the conscious purpose test that appellant has proposed, that's unduly strict. And I don't think that that is consistent with any of the law in this jurisdiction or the common law. And I think it would leave a lot of blameworthy conduct that would be unpunished.
But isn't it completely consistent with attempt law?
Well, not necessarily. I think attempt law, you have to have an intent to commit the crime. And that is the blameworthy state of mind plus a substantial step. So even though attempt law uses specific intent, as I think this court said in the Smith case, which was a reckless endangerment of a child case, that notion of specific intent for attempt purposes doesn't really address the mens rea in the recklessness context. It wouldn't make any sense. So we would submit, Your Honor, that in terms of recklessness, this court has recognized recklessness for a long time in the ADW context. Appellant acknowledges that, and that's been true even in the common law. Appellant says, well, weapons are different. The reading that appellant is drawing here would have really pretty substantial consequences for this court, because simple assault would no longer be a lesser included offense of ADW. It would no longer be a lesser included offense of felony assault or aggravated assault. And it would not be, I think, in accord with the way the court has defined the mental states for manslaughter and the conscious disregard there, as the court explained in Comber. So the analysis of recklessness and conscious disregard is woven very well into this court's criminal jurisprudence, and we don't think the court should depart from it. Now, appellant has suggested that we should have a different test because offensive touches are different than the regular assault of somebody punching somebody. And I agree that there are statutes that have delineated distinctions among different kinds of assaults in other states. I agree with that. But that doesn't matter for our purposes, because our jurisdiction has a common law offense of assault. Assault is a unitary concept. And this court, we submit.
I'm sorry, in what sense is this a unitary concept? I mean,
It's one
I guess
word. It's one word
Well,
that
the statute
defines
actually says assault
multiple.
and menacing threats, so it's got two halves even in the statute that we treat as the assault statute. Maybe we should be calling it the assault and menacing threats statute and treat menacing threats as a different concept.
Well, I think menacing threats are, that's a separate question. I don't know. I've not seen the court address that point.
Right, but in any event, again, I'm a little puzzled about what you think we should be doing methodologically, because I understand your view to be that we're not frozen as of 1901, and that we are, part of the genius of the common law is that we can, within some constitutional constraints, figure out what makes sense for the law of simple assault. That's one of our responsibilities. So why, if it did make sense, in your view, couldn't we say, well, we're going to treat offensive touchings one way, and they're going to have a different mens rea? We could, whatever makes sense, I thought, on your view, subject to constitutional limitations of notice.
I think that the way that the court has treated assault historically has been that it encompasses a wide range of contact and conduct. And I think for this court to then depart from that would not be consistent with the way that the court has heretofore addressed assault.
I'm not sure anything would be consistent with the various ways we have previously addressed assault, but certainly one strand, there are some strands where we say, here's our global definition of assault, and we do treat it as a unitary concept. There are cases that are like that. There are others that say, well, assault has 4 different kinds, and here are the elements of the first kind, and here are the elements of the second kind,
Right.
here are the elements of the third kind. Both of those have some roots in our
And those
prior law.
elements all have the same mens rea, even though there's different conduct, and that's my point. And the other thing I would say, Your Honor, is let's just talk about it as a practical matter. It would be very unworkable if the court were to do what appellant's proposing, because the same conduct could be an offensive touch versus an attempted battery versus a threatening kind of conduct. How do you decide? You're going to give a jury the same conduct that you could argue under 3 different types of assault, but with different mens rea? Doesn't make sense.
When you talk about the mens rea that you're proposing, the purposeful, knowingly, and recklessness, would the conviction here be sustained under a purposeful standard and a knowing standard? I know you believe it would be.
I think for
recklessness.
sure under recklessness. Knowledge, I think also the judge's comments would support it. Purposeful, I'm a little bit more leery of affirmance because the court did say below, the trial court did say, I find that the defendant didn't have, and I forget what he said, the conscious purpose or something to offend. I forget exactly the judge's words. But,
Could it be sustained without remand under the recklessness
Yes.
standard and under the knowing standard, in your view?
I think so, although I think it is a close question, and I'm not going to disagree that the court did use the term, the intent to do the act is all I need to find. The court did say that. And so if the court has some heartburn about whether or not that formulation might have led the trial court astray, well, then the remedy is to remand and have the trial court reassess the facts it found under the state of mind that we think should apply.
Don't we have to, given what she said? The question isn't really whether there's evidence that would support the recklessness. It's whether she, what would she have thought of that now that we give her the new, if we clarify the
Well,
elements
I
of
think that the best indication, I think in support of the government's position, would be the comments the judge made at page 6, which were objectively a person reasonably would find that intentional conduct, in this case, after the warning, to be objectionable and offensive. So the judge, if you read that comment taken by itself, that this was an intentional contact and it was under circumstances that make it objectively offensive, that would, because of the knowledge that the defendant had of the offense, you could, I think, under that, sustain the verdict as a knowing, or at least, at the very least, reckless offensive touch.
But isn't, it's, the language is on the next page,
Right.
right? Where the court says, look, there's some discussion and done about whether or not the person intended for the act to be offensive. And I'm not taking that into account at all, because I don't think that kind of intent is required. I think there has to be an intent to do the touching, but there does not have to be an intent to be offensive. So, why don't we have to go back and say, whatever the mens rea is, knowledge, purpose, recklessness, this judge didn't look at the intent to be offensive at all.
Judge, I'm not fighting hard on this point. I understand that that is somewhat ambiguous, but I think that the question, you could read that comment as saying, I don't find that the defendant had a conscious purpose to offend, and rather, he acted knowing, and he acted aware and taking the risk that he was really going to tick this guy off. He was really going to provoke him. And I think if you read the verdict as a whole, that's a fair construction of the judge's findings of fact and verdict. In any event, Your Honor, I see that my time has expired. We would respectfully ask that this court affirm the conviction, or at the very least, to remand it such that the court address the appropriate mens rea under either purpose, knowing, or reckless conduct with respect to the offensive touching that occurred in this case. Thank you, Your Honors.
Thank you. Ms. Wayne, you have a few minutes reserved for rebuttal.
I want to just quickly at first address the government's position that treating reckless use of a dangerous weapon as a sufficient substitute for an intent to injure would make simple assault no longer a lesser included of ADW. I think this court's en banc decision in Tolles, where it held that second-degree murder is a lesser included of felony assault, first-degree felony murder, is analogous in that although it wouldn't meet a strict Blockberger test, the fact that the common law treated the intent to commit the felony in felony murder as a substitute for malice makes the LIO analysis work. And I think that would be directly analogous here. So I don't think that's a problem, and I don't think this court really even needs to decide that. But more broadly speaking, I want to address the government's position that this court, because we have common law assault, this court is free to expand the definition as it sees fit for policy reasons. Number one, we think that is that it would violate the separation of powers, that it is the Supreme Court has said since 1812 that it is the legislature's job to define crimes and not the courts. This court has followed that admonition, and when it looks to define the elements of common law crimes like malicious disfigurement in Perkins, manslaughter in Comer, it has looked to what the definitions of those offenses were at the time of the common law, at the time of the statute, not sort of as an evolving thing that judges can change or expand to fit policy. But even if it were. I thought
in Comer, although of course we looked to that law, but I thought in Comer we expressly said that we didn't view the common law of the crime of homicide, the various crimes of homicide at issue there to have been frozen in 1901. I thought we expressly said the opposite of that in Comer.
No, I think what this court did was it quoted a phrase from a different case that said that the common law is not frozen, and I agree that in areas where common law development of law is appropriate, such as torts, such as rules of evidence, such as contracts, no, of course the common law is not frozen. But I think that as a matter of separation of powers and due process, that when it comes to defining the elements of a crime, that's absolutely the legislature's job.
Suppose the common law says, well, the mental element of this crime is general intent, and that's all we have. And now we have a case and we say, well, now what the heck does general intent mean? We haven't got the foggiest idea. Now we can say, well, the common law is vague, so there's no crime in the District of Columbia of simple assault anymore because we simply can't give it a definition or can't work with the definition given by the common law. Or we can say, well, we've just got to figure out what is the most sensible understanding of general intent. Does that violate the separation of powers and other constitutional concerns?
No, if your job is to try to come up with what is the definition of general intent under general common law statutory interpretation principles, for example, that would be interpreting. That would not be saying, here is what common law said. Common law said intent to injure, but we think that's too narrow. We would like to expand it to recklessness, to fit more crimes, to punish more conduct. That would be legislating. And I think even if this court thought that were appropriate, there is no policy reason, and no state legislatures that do policy have found it prudent to criminalize reckless offensive contact other than maim. And so the government hasn't given this court any, pressing policy need to expand the definition of simple assault to include recklessness.
Wayne,
Again,
is that the main area? As I listen to the arguments today, there seems to be far more commonality between the arguments that the appellant and the government are making here. Is the main area of disagreement the recklessness prong? You don't seem
think
to
so.
object to the purposefully and knowingly standard. And then with respect to the actus reus, can you maybe clarify where you may
where we
differ?
disagree, yes.
Yes.
So I think that, we think that for a touching to rise to the level of an injury that is a crime, that the touching has to be more than just unwanted or irritating or annoying. It needs to rise to the level of that this court described in Boussolet and in Ray of highly offensive, spitting, sexual contact, Boussolet, fear, shame, humiliation, or mental anguish. And it needs to be basically that if different people are offended by different things. People have different sensibilities. And if we're going to have a criminal law that people know how to, that it needs to inform people how to govern their conduct. And so it needs to be offensive to a reasonable person, and it needs to basically be a virtual consensus that everyone's going to think this is offensive. Otherwise, how can it be a crime? And I think that's where we differ. I think that in our view, the mother who grabs her son's hand despite his statement, "I don't want to be touched," is not doing an offensive touching. I think that
Because under those circumstances, so
under those
you look to the
circumstances,
circumstances.
whereas a stranger, yes, maybe a stranger, yes. And we think that the facts of this case are closer, I'm not saying they're exactly the same,
So the
to the mother.
dignity of the person analysis or language that comes from some of the older common law cases.
I'm sorry, can you say that again?
The role of simple assault in protecting the dignity of the individual, and that dignity meaning, to be free from injury, insult of a certain magnitude,
Yes.
which is how the government framed it, borrowing in part from some of the language of our common law cases. You don't take issue with that?
No, I
language?
don't. I just think that it needs to be of a heightened, that the type of offense needs to be of a heightened degree and it needs to be almost universally agreed upon that, that this is really offensive. This is like spitting. This is like sexual touching.
Here's where I get puzzled. It seems to me a hard part of this case is what circumstances you wrap in. It's a recurring topic in objective, subjective.
Right.
At what point, if you start wrapping in all the circumstances, are you getting into a subjective test? I take it
No,
you
I
are
don't think
agreeing.
so.
Again, it's hard to answer the question in the abstract. Is there a general consensus that you'd find it offensive to be kissed on the lips? I can't answer that question. It would depend on the context as well. Is it my boyfriend or girlfriend, or is it someone who doesn't know me? And so if it's a totality of the circumstances test, you seem like you're descending to particulars that make it hard to know what the general consensus would be.
Well,
So,
I think
that's
Yeah.
a prologue. I apologize
I'm
for
sorry.
the prologue, but it's on me. I'm not sure I know whether you think that an expression by the person who is touched before the touching, "Don't touch me that way," whether you think that's irrelevant, or whether you would acknowledge that it is relevant, but you just think it can't be categorically sufficient, but you agree it's part of the totality of the circumstances.
Yes, I
Is it the
agree it's
latter?
relevant. It's very relevant. I think if the same touching that the mother did was a total stranger, if I'm walking down the street and a man grabs my hand and I say, "Get away from me," and he continues to grab my hand, that is very, very different. And I think that the fact that I've told him, "Get away from me," and the fact that he's a stranger, I think this is not like that. Our facts are that Mr. Tarawali says that he's close friends with Mr. Perez-Hernandez, that he views him like a little brother.
Ms. Wing, if I could interrupt it, because what I'm hearing, and tell me if I'm wrong here, is that there's not really much disagreement in how you or the government would define the actus reus element. The disagreement is how you look at the circumstances and facts in this particular case and whether they meet that particular standard.
I disagree, because I think the government is saying that offensive means that actually, I'm not sure. Maybe I think, they did cite the fear, shame, humiliation, and mental anguish language in their brief. I don't remember whether my opposing counsel said that she thought that I think she had said that annoyance was enough. I'm not sure. But to the extent the government thinks that sort of any displeasure at a person's touching is offensive, then we would disagree with that. But to get to the facts of, I'm sorry, I did just want to also say that to the extent that this court thinks that it has the authority to expand the common law definition, that there has been no policy reason identified to do so, and that would be contrary to the policy decisions of the vast majority of states, overwhelming majority of states in the nation. And it would be contrary to tort law, that not even tort law recognizes reckless offensive contact as a tort. And it would be highly anomalous to say that reckless offensive contact is a crime, especially because offensiveness is such a difficult thing to understand, or just to clarify. It's not a bright line rule, that it will depend on the totality of the circumstances. That if you're going to make it a crime, that criminal law ought to have a clear and sort of everyone agrees standard of this is offensive, it's offensive to anyone, and that it needs to be intentional. Now, on the facts of this case, we don't think that the evidence was sufficient to meet that standard, because there was no evidence whatsoever about the demeanor or tone of the conversation that was accompanying this touch. It's a touch on the arm, which is an extremely innocuous touch. There's evidence that Mr. Perez-Hernandez is sort of just a demonstrative person. He tends to touch people when he talks to them, and that Mr. Tarawali viewed Mr. Perez-Hernandez as a very close friend, almost like a little brother. And so we think this situation is far more like the mother's perhaps annoying, irritating touch, but not one that rises to the level of an injury, a fear, shame, humiliation, or mental anguish that the criminal law ought to punish. Thank you.
Thank you. All right, the court would like to thank both counsel and parties for your arguments and briefs today. We also note that the Office of the Attorney General for the District of Columbia submitted an amicus brief in this case, which the court has reviewed and considered. So thank you all.
All right.